Well, who do you think brought them?
I thought I had a party.
Huh?
I thought it was an injured party.
The injured party, aren't they dope cases?
What is the jurisdiction of it? Is it criminal or
I
civil?
don't think you're near as smart as you think you are.
I'm just asking questions.
Yeah, you're not. Your possession of a controlled substance, giving false name, causing adverse effect. I guess there could be a victim on that, and resisting officer without violence. So, I don't know anything about the case, but it looks like you might have got a false, gave somebody else's name.
You just told me that the state was the.
The state's the only person who can charge you. Nobody else can charge you. It's the state.
Viewers, today's courtroom drama comes loaded with excuses, confusion, and a surprise sovereign citizen cameo no one asked for. First up, Jaden Larry, convicted of strong-arm robbery, stepping into sentencing armed with nothing but a stack of complaints, from false ping data to witnesses vanishing into thin air. He even tries to explain away incriminating audio by claiming he said Lex, not licks. And if that wasn't wild enough, just wait. Because a second defendant later decides today is the perfect moment to question whether the state of Florida even has jurisdiction over controlled substances. And trust me, the judge's reaction? Yeah. You'll want to see where that goes.
Jaden Devon Larry, and this is case number 23-4199. And we're here today on the sentencing. The jury has returned a verdict of guilty as charged of robbery and failed to make any special findings. Is that correct? The state and defense ready to proceed to sentencing?
Judge, one of the issues when the verdict was returned was whether it was a true verdict because there was no special findings. Based upon the research that I was able to locate, and I think Mr. Sullivan came with the same case law that I did. It stands for the lowest robbery. So we did look at that. So I think he's to be sentenced on a simple robbery, which is a second-degree felony.
There was no enhancements filed. No, it was.
I did, Your Honor. I did file a notice to seek the violent habitual felony offender. I'm not going to be doing it this time based on the case law earlier. There's some dispute about whether there needs to be a jury finding of those things or not. So, out of an abundance of caution, I will not be proceeding forward on that.
All right. And prior to coming to court today, I reviewed some couple letters in support of Mr. Larry. I think they were, I don't know if they're in the court. I know there's some correspondence in the court file, but they were provided to my office.
Is it from his
from
mother?
One employer I know, and one that of maybe a some sort of after school or.
While Mr. Sullivan's reviewing that, there was also some family photos that Ms. Rolak provided, if the court would like to see those.
Okay. I've reviewed the letters. I reviewed the letter from Ms. Rolak. I reviewed the pictures. And Mr. Meredith, anything that you and Mr. Larry would like to put on the record prior to sentencing?
Yes, as far as what you've received is basically kind of a slanted PSI towards us. So if PSI was necessary, I think you've received that information that you would have. So he has never been sentenced to Department of Corrections. So if PSI is required, I think you've got
what I would get from a PSI. So
yes.
You're willing to waive that at this time?
Yes, sir. And I believe Mr. Larry did want to put some things on the record and address the court.
All right. Go ahead, Mr. Larry.
I don't want to take too much of your time up. You feel me? I know you got a busy day, but you know, as the process been, a lot of things happened during the process. You know, with first jury selection and stuff like that, it turned into a Richardson hearing because of a lot of evidence that wasn't presented 5 months ago after we asked for it prior up to that date. And, the Williams rule hearing came after that. And, things were said. I think everybody could conclude that they couldn't, nobody said it was me. He couldn't identify me as a person. And there was no physical evidence in none of these cases, but a pair of alleged slides I was involved. And the day of the trial, more evidence came up that I didn't never see, my attorney never saw. It's clearly a discovery violation, Brady violation, however you want to call it. But, I know everybody's doing the best of their ability to make sure everything gets seen and viewed. You feel me? And I appreciate my attorney for everything he did at trial, Ms. Beasley, and as well as Mr. Sullivan. He's just doing his job. You feel me? But a lot of things with the witnesses, I was expecting one to be here. She didn't show up, but I guess she got denoted or whatever. I didn't know all this to the last minute, but even at trial with the detectives saying they couldn't ping my phone, and they did ping my phone. They had a search warrant for all of this. They did a tower dump, stage 1 and stage 2. I was never in the location. So it was just a lot of stuff that was said at trial that was actually false. And you feel me, about the hitting licks thing. I was never talking about licks. My girlfriend's name is Lex. That's probably why he said what he said. Oh, I didn't know. That's what it sounded like. I never said that. I never gave any admissions or any involvement or any knowledge of the crime that was being committed. So in the process of all this happened, a lot of stuff that I didn't agree on, a lot of stuff that I felt should have been objected on, even the speculations of the robber hopping into the vehicle that was never seen, never happened. And it was just a lot of stuff. But, Your Honor, I appreciate everything Mr. Meredith did. I appreciate everything Mr. Beasley did. Everybody just doing their job. You do what you do to the best of your ability to be fair and impartial. And I want to thank my mom and my girl for being here as well. And everybody else.
Mr. Meredith?
I respect the jury's verdict because they sat through it, but I do respectfully disagree with their finding. As Mr. Larry pointed out, you are familiar a little more deeply than the jury was because of the Williams rule hearing and then hearing the testimony at trial. Mr. Larry made no admissions. The DNA on the slide was a mixture. There was never an identification of Mr. Larry as being the person that robbed the Dollar General October 18th.
Hold it down just a little bit, okay?
To my mind, there was more than reasonable doubt. There's another time for dealing with that. The state has shown me a score sheet which appears correct, where the lowest permissible sentence is 25.5 months. Based on the facts and circumstances that you heard throughout this case at various hearings and in trial, I'd ask for the lowest permissible sentence with no probation to follow. He has 464 days credit against this.
State?
Your Honor, while typically a court cannot consider lack of remorse at sentencing, the case law is clear that if the defendant testifies at trial or voluntarily testifies during the sentencing hearing, the court then can consider the voluntary statements that were made and the lack of remorse at that time. So I'm asking the court to consider Mr. Larry's lack of remorse based on his statements here today. Additionally, based on Mr. Larry's score sheet, as you can see, he's got a prior violent felony for carjacking. This is not his first violent offense. In fact, he was actually...
Internet. This is where everything comes undone. Mr. Larry's attorney is pushing hard for the lowest permissible sentence, arguing reasonable doubt, mixed DNA, no eyewitness ID, the whole package. But the prosecutor fires back with something sovereign citizens always pretend doesn't matter: criminal history, probation status, prior violent felony, actual verifiable facts, not phone tower conspiracies or they misheard me saying Lex defenses. Then the prosecutor drops the bomb. Lack of remorse. And here's the thing. Sovereign logic always collapses here. Courts don't care about vibes, theories, or personal interpretations of case law. They care about whether you admit responsibility. Meanwhile, the audience is thinking the same thing I am. How do you blame everyone, deny everything, and still expect leniency? Let me ask you this. Chat, have you ever seen a defendant talk this much and help himself this little?
On probation for that carjacking offense at the time. So I'm asking for a harsh sentence in this case, Your Honor. Mr. Larry is not a first-time violent offender. He was given a chance the first time he was sentenced on that carjacking. Did not take anything from that. So I'm asking for the maximum 15 years in this case.
All right, this time, Mr. Larry, a jury of your peers has found you guilty of strong-arm robbery. It is my obligation now to sentence you as follows. You'll be adjudicated guilty of robbery, sentenced to 15 years in the Florida Department of Corrections. Given credit for how many days? 464 days time served. I am going to set restitution amount of $600 to Dollar General. That's reduced to a civil judgment. Your assessed fines and costs of $1,028. Those include discretionary costs of $2 of local law enforcement education, a $65 assessment of additional court cost, a $150 discretionary public defender fee payment, and a $200 discretionary fine. The fines and costs are reduced to a civil judgment. Of course, since it's a 15-year sentence, there's no probation to follow. All the fines and costs and restitution are reduced to a civil judgment. Mr. Larry, you have 30 days to file your notice of appeal. If you wish to appeal this judgment sentence, if you'd like to have an attorney to represent you, you can't afford one. One may be if one to represent you at no charge. Good luck to you, sir.
Two other things real quick. The restitution amount, the $600, that was something that Mr. Meredith and I spoke about. There was some conflicting numbers about the exact amount that was taken. I suggested the lowest amount so that's where that 600 came from. I believe that's been agreed to, and that's why that was submitted.
Mr. Meredith?
As a civil judgment, it's
And the other thing, Your Honor, the state at this time would consolidate the other 3 cases that Mr. Larry has.
He's released from whatever bonds are on those, and those have been consolidated.
he has family locally. If you'd like to be held in Bay CI, if possible. Or,
It doesn't. I guess.
I would just recommend the Florida Department of Corrections house Mr. Larry closest to Bay County.
But can you put on a record that you?
yeah, I had spoken with Mr. Larry last week that he didn't even have to ask me. I was going to have the appeal prepared, and it would be filed by the end of next week.
Mr. Meredith will file the notice of appeal, then the Second Circuit Public Defender's Office will handle the appeal over in Tallahassee. Okay?
But I'll get the record perfected and get everything up there. All right.
All right. You need to step over and be fingerprinted. Mr. Larry? Meredith?
On the morning docket, you had continued Kareem Williams from, I believe it was last week, the out of custody pretrial, because he wasn't able to get to Panama City.
Okay. Come on up, Mr. Williams. Okay.
Judge, he had been offered a pretrial intervention. We had supplied that to him, and I'm not sure what his intentions are. All right.
You understand a pretrial intervention is an agreement you have with the state that's basically supervised by the probation and parole, and then the case is dismissed if you successfully complete the that term.
Could you repeat it?
Pretrial intervention is a program that's offered by the state, and it's supervised by the Florida Department of Corrections. It's like probation, but it's not probation. It's an agreement that if you successfully complete the pretrial intervention, the state drops the charges against you.
I spoke with my public defender, and he gave me the terms and the things that I have to do, and I didn't agree with him.
Okay.
And I don't understand.
Sir?
I don't understand. So, like, the charges would be dropped.
If you successfully.
If you did
you'd have
all
to-
those
You'd have to
terms.
abide by those terms and conditions, and the case would be dropped.
Could I ask a couple questions?
You ask Mr. Meredith.
Yeah, I mean, I spoke with him shortly. I didn't really get all I really spoke of, what we went over was the terms.
We had several phone conferences that were scheduled.
Yeah, we missed a lot due to the time difference.
Sir?
I said, but we missed a lot due to the time difference.
He was on Eastern time and he would call an hour late.
I mean, a pretrial intervention is about as good as it gets. If you can take it or not take it, are we ready to set it for trial?
Yes, sir.
I don't want to do trial.
Well, then Mr. Meredith has done exactly what he's supposed to do for you. He's got the very best deal worked out for you. If you abide by the terms and conditions of the pretrial intervention, the state will dismiss the charges.
So the charges are brought upon me are by the state.
Well, who do you think brought them?
I thought I had a party.
Huh?
I thought it was an injured party.
The injured party, aren't they dope cases?
What is the jurisdiction of it? Is it criminal or
I
civil?
don't think you're near as smart as you think you are. I can
I'm just
tell,
asking
I can
questions.
tell you're not. Your possession of a controlled substance, giving false name, causing adverse effect, I guess there could be a victim on that, and resisting officer without violence. So, I don't know anything about the case, but it looks like you might have got a false, gave somebody else's name.
You just told me that the state was the.
The state's the only person who can charge you. Nobody else can charge you. It's the
Oh.
state. The victims can't charge you. They're just the alleged victims. They can't charge you. They can't do anything except make a complaint. But you've got to offer a pretrial intervention. If you do the pretrial intervention, the state will drop the charges against you. If you don't meet the pretrial intervention, you come back to court and you start your defense again.
I don't wish to argue the facts.
Let's set it for trial.
Yes, sir.
Let's set it for May 5th at 8. Let's set it for June. What was that June date? June 2nd at 8:30. And will be May 23rd at 1:30 for trial management. And if you change your mind and want to enter the pretrial intervention, you probably need to discuss that with Mr. Meredith. But remember, he's on Eastern Standard Time. Okay?
I'm on
He's
Central.
Central Standard Time. You're on Eastern Standard Time. Okay? If you'll step over and sign a notice. Safe trip back to Gainesville. Step right over here and sign a notice, sir.
Team, the ending of this case shows exactly why courtroom reality always outmuscles sovereign CT fantasy. After hours of testimony, objections, evidence battles, and Mr. Larry's long list of disagreements, the judge does what the law requires. 15 years in the Florida Department of Corrections, plus restitution and civil judgments. No probation, no wiggle room, no magic words that undo the verdict. And it doesn't stop there. The court even consolidates his other pending cases and sets up his appeal pathway, everything by the book, everything procedurally clean. Meanwhile, the contrast between Mr. Larry and the next defendant, Mr. Williams, is almost comedic. Williams dips straight into the classic SovCit starter pack. Who's the injured party? What's the jurisdiction? The judge shuts it down instantly. Because in real-world criminal law, the state brings charges, not some imaginary contracting party. This whole hearing is a masterclass in what happens when defendants rely on misunderstandings, myths, or YouTube law advice instead of strategy. Courts run on statutes, evidence, and procedure, not loophole hunting. Sovereign tactics don't just fail, they usually make sentencing worse. If you're into real courtroom consequences, breakdowns of legal fails, and sovereign meltdowns just like this, hit that like button, drop a comment, and subscribe for more cases every week. And don't forget the bell. you won't want to miss the next one.